because I myself experience how this can declog the court docket and how mediators can not only settle disputes but ensure peace in our society. And the Katarungan Pambarangay, although we cannot do anything to expand the jurisdiction of the Katarungan Pambarangay because that will require a legislation to amend the Katarungan Pambarangay, but perhaps the judiciary can support that. We are still relying on the penalties provided in the old, in our penal code, which was taken from the Spanish penal code. And so if we go by the penalty provided for crimes under the revised penal code, there will be a lot of cases really excluded from the Katarungan Pambarangay law. So I think that we should give priority to that because the lack of public trust and confidence is brought about by the delay in the disposition of cases. The more cases we have before our courts, the longer it takes for them to decide the case. We were told that the way we are treating cases in court is like distributing delay. Because, the courts would schedule 10 or 12 cases in a day and then let this case be heard for 30 minutes or one hour so that everyone will have time to be heard. But litigants expend a lot of money to go to court only to be heard for 30 minutes or for 1 hour, and then the case is reset for after 3 months or 4 months. So our system is really contributing delay among all the parties litigants. So when I was a presiding justice in the Sandigan Bayan, we were experimenting on continuous trial. It is difficult to just impose it right away, but it has to be done gradually. So what we did when I was there was to select simple cases, cases where the crime involved is not so difficult to deal with, cases where there is only one party involved or one accused involved, because there are cases there where there are 25 accused, and these 25 accused would have 25 lawyers. It's so hard to hold continuous trial in that case. So we were starting with simple cases, and I think we should try to experiment on that. I didn't know what happened when I left the Sandigan Bayan. I no longer was able to see what happened if they continued with the experimentation. So there are so many ways of improving access to justice, making it more speedy, making it more efficient, and we just need to have this political will to be able to do it.
Thank you, ma'am, especially on your emphasis on court annex mediation. As earlier told by Justice Carpio, our success rate is 78%, which is quite high. So that's an average of 7 out of 10 cases referred to for mediation are actually settled. Mm-hmm. And that really dramatically reduces the court docket. Plus the fact, and perhaps many do not know this, that you don't have to be a lawyer to be a mediator in court annex mediation. And no matter what the amount involved is in the case, a mediator gets the same fee. Okay, so it's something like 700 or 800 pesos. So it's really, actually it's also public service. It's a form of public service to be mediator, and I think it's necessary for them to get the right support through training so that we can ensure the continuity of the program. I just have 2 more points, ma'am, if I may. In your long career in public service, do you recall of any instance where your independence was put to test when you had to make a decision against the wishes of the appointing power?
I'd like to say that I have been very lucky in the course of my career, whether it was in the Department of Justice or here in the judiciary. I have never experienced any pressure at all. I was allowed to do what I believe was right. Because if you have established that reputation, that you know what you are doing, and that you have integrity, I don't think anybody would ever try to influence or pressure you. Because I would take that to be an affront to my dignity if anyone would ever do that to me. So, and fortunately, I have not experienced anything like that in the course of my long career in government, whether it was in the Department of Justice. I'm very happy to have very decent superiors in the Department of Justice during all the time that I was there. And even now in the judiciary.
Thank you, ma'am, for that answer. And for my final question, if appointed Chief Justice, a lady Chief Justice at that, how would you characterize a De Castro court?
I'd like to be remembered to be a court which is independent, where independent, efficient, where integrity is upheld, and where people have trust and confidence. And that we want to be remembered, I want the members of the court to be remembered as models of exemplary behavior and decency.
Thank you, ma'am. With that, I wish you luck. Thank you, Justice Leonardo De Castro. Mr. Chairman, I have no other question. Thank you.
Thank you. Attorney Mejia, please.
Thank you, Mr. Chairman. Good afternoon po, Justice De Castro.
Good afternoon.
I understand, and based on our record po, you were previously nominated as, or you were previously interviewed as for the position of Chief Justice already. Were you shortlisted?
Yes, I was.
Kung halimbawa po na kayo ang napili noon, what would have been a De Castro court today?
I would hope that there was no impeachment, that I would not be subjected to impeachment, and that we're able to continue on with our work in peace.
Talking about the impeachment po, as you know, the one of the major issues in the impeachment was the SAL-N, no? Kanina po, paglabas ko, may nagtanong from the media sa akin, Sir, why are Supreme Court justices hesitant to submit their SAL-N? Sabi ko, alam mo, ba't ako tinatanong mo? Hindi naman ako. Sabi ko, itatanong ko yan mamaya. So, itinatanong ko po, is there hesitance really on the part of associate justices or justices of the Supreme Court to submit their SAL-N? Kung meron man po, why?
No, I don't think there is hesitance. Because when we were appointed to the Supreme Court, there was already that old guideline. So we were just following the guideline. And that guideline was adopted because the court was worried about harassment being done to the justices by disgruntled parties. Now, if in the spirit of transparency, since that was regulation was adopted a long time ago, and many things have changed since then. There is greater demand now for transparency and for accountability. So I believe that we should give in to the popular demand and lay everything out. Anyway, we're not hiding anything from the public.
Thank you po. You mentioned earlier, no, in fact, in your opening statement, that you have formed the opinion that the court should exercise its expanded power of judicial review with utmost care. Can you please expound on that?
The power of judicial review exists within our system, constitutional system, where there is a separation of power, a system of checks and balances to ensure coordination, a harmonious coordination among the three branches of the government. And I have come to know in the course of my work in government that the legislators and the president oftentimes are required to make policy decisions. And their policy decisions are based on many factors. The members of Congress have to know the pulse and the sentiments of their constituency, the people who elected them in office. So do the president. He has a constituency it's a bigger audience to address when he takes official action. And aside from that, they have technical information which are not within the reach of the court. The president is concerned about national security. He would have classified information on military matters, technical studies on matters affecting the economy. And he is confronted with the problem of our overseas contract workers. Not only because they are sending us dollars and helping the country through their remittances, but also these thousands and millions of overseas contract workers have families here in the Philippines. So the president has to take care of them. We have our foreign relations. Other countries may restrict trade, the export of Philippine products if we take a particular action that is not to their liking. We are attracting foreign investment. There are so many things that the president would have to attend to. So the court should understand that we do not have all of this information, and so we should be very careful in declaring unconstitutional the acts of the officials in the political branches of the government.
How would you maximize po in your court the role of the court administrator?
I think the court administrator must be proactive. He should be able to reach out. In the course of the implementation of the judicial reform project of the court, I had the chance to go around to meet with our judges. And I know that face-to-face discussions between ranking officials of the court and the judges on the ground will contribute a lot to solve problems and to speed up the disposition of cases. Like for instance, in Lapu-Lapu, it took me only two meetings with the judges there, and there was a marked improvement in the disposition of cases. I had to go to Lapu-Lapu because that is a model court. And so I think the court administrator must be accessible to the judges, spend enough time hearing them, listening to them, and discussing with them the problems of the court.
Ng pagkakataon yung ibang naimungkahi na katanungan para itanong sa inyo, no? Yung iba po comment at suggestion. Ito siguro, kung magbobotohan siguro at hindi appointment, palagay ko baka manalo kayo by popularity. Kasi po, sabi niya, maari bang i-consider ninyo na yung mga bumabagsak sa bar, yun na lang binagsak nilang subject sa bar, yun na lang ang kanilang i-take? Ano po ang opinion nyo tungkol doon?
Hindi naman masamang pag-isipan yan. Lalo na kung matataas ang grade sa ibang subjects. Every time that we are deliberating on the passing mark in the bar exam, I always take into account those who are to be disqualified. Kasi I have known a case where this examinee could have topped the bar, but he was disqualified in one case. So there may really be cases where it is not just to make them go through the entire examination, but this will require a lot of study, and perhaps we need to evaluate. I don't know if we're capable of evaluating the examinees individually, because it's so hard in a situation like that to generalize. So perhaps we could first take some statistics to see how many failed just in one subject but got very high in other subjects, for us to reconsider this policy of the court.
Thank you po. Ito ho, natugunan na nasagot na po ni Justice Abad kahapon, pero paulit-ulit po yung tanong. Siguro, baka hindi nakikinig kahapon itong nagtanong nito. At hindi lang po isang nagtanong. Baka po maikling short comment po again dun sa trial by jury. Mukhang sabi ko nga marami ang nabibighani sa panonood ng law and order. So can you please again give us your take on the matter of adopting trial by jury? Briefly lang po.
I'm not in favor of adopting trial by jury. You know, in the US, that has a very, very long history. It's part of their culture. Hindi yun parte ng kultura natin eh. And I don't know if the citizens will be willing to devote time to the trial of cases. And sometimes there is also that problem. In the US, they have a problem with that. They need to orient the jury members. They need to be told what are the issues, what they should look for, so that will put additional strain on the operation of our justice system. In the US, they allow this both in criminal and civil cases, but to a lesser extent in the case of in civil cases. But I know they are encountering a lot of problems because they are paid. That's additional expense. But the pay is not also enough for them to leave their family or to leave their work. And there is also a problem, I think in the US, before, they want to make sure that the jury members do not read the news, do not watch the television, or do not know anything about the case. But how can you do that now with the internet and all these gadgets? You cannot anymore sanitize the jury members. You cannot seclude them from what's happening in the society. And I think the important thing in the jury system is that the members of the jury do not know anything about the case, have not encountered anything in connection with the case, so that they can be objective. They are finders of fact in the jury system. The jury finds the fact for the judge, and the judge would apply the law. But there are also occasions where the judge do not agree with the jury. So you add more conflict in the criminal justice system, and there is disagreement between the judge and the jury.
So yun po, sana nalinawan yung mga nagtatanong, kasi ang dami pong nagtatanong tungkol sa jury system. My final question po, paano ninyo maitataguyod ang women empowerment sa Supreme Court?
Sana marami pang ma-appoint na lady justices, lady judges. Kasi I say this because if you consider the ratio, there's still a big gap, no? We have only 609 lady judges and justices from the highest court down, and this comprise about 33% of the entire membership of the judiciary. So I think in that area there can still be room for improvement. And I know I don't have any gender bias against the men, but I'm just saying that from my experience, I feel very much fulfilled working with the lady judges. I would not have been elected president in the International Association of Women Judges if it were not for the cooperation that I got from the officers, directors, and members of the PWJA. Many of them are very diligent, very capable and competent, very dedicated to their work. And I think the Supreme Court can utilize their this spirit of cooperation of women judges to be in the implementation of our judicial reform projects in the Supreme Court.
Thank you, Mr. Chairman. Good luck po, Justice De Castro.
Justice Lagman, please.
Thank you very much, Mr. Chair. Justice De Castro, good afternoon. During the impeachment trial of the former Chief Justice, the moral fitness of a Chief Justice came out. In your perception, what is moral fitness, which should be one of the criteria in nominating and appointing a Chief Justice?
I understand moral fitness to mean not simply obeying the law.
Yes.
Because you should transcend that. You must see to it that your actions are in accordance with proper, decent, and that you do not go beyond the bounds of ethics. So it's not enough to say that I'm obeying the law, I'm following the law. But we should be very careful in seeing to it that we observe decency, propriety, and ethics in all our actions. And not only in our official actions, but also in our private life. We should be models in our community. Models of moral fitness.
Okay. You have stated that you are the vice chair of the Ethics and Ethical Standards Committee in the court, so I'll ask you this question. It is of common knowledge that the judiciary now is burdened by an image of corruption allegedly committed by most of its members. Now, former Chief Justices have tried to address this problem, but apparently they failed because this problem still persists up to today. If you will be appointed as the next Chief Justice, how are you going to root out the corrupt in the judiciary?
I think it is important for us to have a feedback mechanism.
How are you going to do that?
Yes. We should enlist the support of the integrated bar and the community in this feedback mechanism. I don't have yet the form of this feedback mechanism, but I think it's a way of putting members of the judiciary on their toes, knowing that
They are being watched.
They are being watched, and that we should have a standard criteria to evaluate judicial performance.
So, can you explain further what you mean by standard criteria? What is the standard criteria that you wish to implement?
Right now, the court is working on this, and it's really a difficult undertaking because, sometimes there are judges who write very well, so it takes them more time to write their decisions, and
Okay.
these decisions are are usually affirmed by the higher court. There are those who produce a lot of decisions, but they are all reversed.
Yeah, okay.
So there are many factors to take in consideration, and we have a problem about finding who should evaluate them. They do not want to be evaluated by the executive judge because they feel they are just peers, and their work is not reviewed by the executive judge. So we should really look into this, have a scholarly and well-studied measure to evaluate the performance of our judges.
Are you telling us that your basis for evaluating the performance of the judges will be their decision, the percentage of affirmance or reversal of their decisions?
No, not only that. That's why I said we should study the criteria that we should use in evaluating judicial performance, and it cannot be as simple as that. There are many things that we should consider.
Okay. Now, Justice De Castro, what to you is accountability? And how are you going to promote accountability in the judiciary?
Accountability means being responsible
Yes.
for your action. It is not enough that you are not found out, because you all somehow, some way, you're going to pay for whatever wrong you have done. There's a higher being there watching over us, and so for me, accountability is not only something legal, but it is spiritual. It transcends what the law demands of us. And I think we should instill this sense of accountability through our Philippine Judicial Academy, the institution in the Supreme Court, which is taking charge of educating and developing the skills and the orientation of judges. And I think we should see to it also that legal education is reformed. I think we have paid very little attention to ethics. It's just a 1-unit course in college. So I think that should be allotted more units and given greater weight in the bar examinations.
Okay. Now, considering that the Legal Education Board is under the supervision of the Supreme Court and the Chief Justice in particular, how are you going to regulate the law schools in that regard through the Legal Education Board?
The Legal Education Board can decide on the curricula of the colleges of law, and I think this is a very potent way of looking at the administration of our law schools. I think the Legal Education Board has enough authority under the law to be able to reform our educational system, especially the law schools. And I think the Supreme Court should be more active. This Legal Education Board has only been recently organized.
Yes.
So
and it has not taken off.
I think the court should have a better or closer coordination with the Legal Education Board. Anyway, it is within its supervision, and not just let it do its work without any supervision from the court. So I think that's one area which the court should also pay attention.
Okay, Justice De Castro, I have here some questions. In fact, there are many questions from our Twitter, which are all directed to you. And I want to ask you these questions. Okay, Justice De Castro, this is from a certain FCA. Justice De Castro, what can you say about the masses, rallies, banners, no work day in the Supreme Court during the impeachment to show support to a justice facing charges?
I didn't have a hand in the planning of these activities. What I just want to say is that anyone who tells me that there is a mass going on in the Supreme Court, I usually attend, whether it is for one purpose or for another. Whether it's for First Friday or for any occasion, I would go to mass and attend the mass. Now, aside from that, during the mass, we pray for everyone.
Okay.
We
Not
pray
only for
for
a
the
particular
prosecu-
person.
Not for a particular
Yeah,
person,
okay.
but we pray for everyone. And I think prayer is very, very good.
Yes.
In fact, I ask so many people to pray for me now.
Okay. Okay,
So-
that's very good.
So,
The power of prayers.
yes.
Now, another question from a certain Felipe Natanyo. How should the Supreme Court balance its response to people's demand for openness and transparency while guarding against tendency to become populist? How should the Supreme Court balance its response to people's demand for openness and transparency while guarding against tendency to become populist? From a certain Felipe Natanyo.
Is there? I do not perceive anything wrong with being populist. If it means that we need to be sensitive to the sentiments of the greater number of our population, I don't see any conflict between these two ideas. I'm both for transparency and also for seeing to it that we feel the pulse of the people without, of course, going beyond the bounds of the law.
Okay. Now, one last question, Justice De Castro. Just from Riola. Justice De Castro, has there been a time when you totally opposed a certain decision of the Supreme Court?
Is it about writing a dissent or?
Yes. Where you have
Oh yes,
completely dissented.
Yes, yes, I do that if I really believe that I have taken the right position.
So in relation to that, another question is this. Has there been a time when you regretted the action which you have taken in a case which you have decided?
Fortunately, I have no regrets for any decision that I have done. I have never flopped or changed my position in the course of my work here.
So you have never flip-flopped?
No.
Okay. So on that note, Mr. Chair, I have no more questions for Justice De Castro. Thank you, Justice.
Thank you. Justice Hermosissima, sir.